the quote that kind of struck me was this. It says, as part of our effort to rid the roads of drunk drivers, the legislature has sought over time to streamline the process by which those charged with DWI offenses are efficiently and successfully prosecuted. Okay? And they have a pinpoint cite to State versus Tissue, and I read this over, and I said, that's not what they said in State versus Tissue. I mean, they're quoting one of the most, I don't want to use the word interesting, that's not egregious quotes, I think, in the history of the Supreme Court. This is an infamous quote, something that really has the kind of the stamp of the Wilentz Court on it, going back to 1987. So I've put the two of them here side by side. You can see what they really said in Tissue was, the legislator, working in tandem with the courts, has consistently sought to streamline and remove obstacles for impeding the efficient and successful prosecution of those who drink and drive. So it looks like the court is out of the tandem business, I guess, with the legislature. And if you stop to think about it, there's really two ways of looking at this. Is this something that's just an oversight by the court, or did Justice Owens really mean to say something here? I'm going to suggest to you this is a critically important kind of a sea change viewpoint from the court. They've taken themselves out of the business of the successful prosecution of drunk drivers and put themselves in a position of neutrality. You'll see as we go through the opinion, there are several occasions where the court will say that zealousness to remove drunk drivers from our roadways in New Jersey cannot stand in the way of fairness in the procedure.
You also see the other subtle change from those who drink and drive in Tissio to DWI offenses in Chun. So there's been a subtle shift away from prohibition to enforcement.
Okay? So keep that in the back of your mind when you're dealing with this, and we'll point out the quotes where they really have some significant changes in terms of advocacy. All right. And if you stop to think about it, why would you go through this exercise with Judge King and Chun and everything if you weren't going to change the way you think about these things? Okay. Now, it's important you understand when you're analyzing the case, this is a 149-page opinion, and like anything else, it doesn't read through in a logical sequence. You've got to think of the Chun decision as like a big puzzle, and you've got to take the pieces of the puzzle, kind of cut and paste them and put them into a logical progression in order to understand how the case works. So the court has its conclusion at the beginning. So sliding over to page 6, we conclude the Alka test utilizing New Jersey Firmware 311 is generally scientifically reliable, but that certain modifications are required in order to permit its results to be admissible or to allow it to be utilized to prove a per se violation of the statute. Some of these conditions upon admissibility we impose as a matter of constitutional imperative. That's going to be primarily Crawford stuff. Others is a matter of addressing certain of the device's mechanical and technical shortcomings that were revealed by John Menzel during the proceedings on remand. Within the framework for admissibility that we here establish, pending prosecution should be able to proceed in an orderly and uniform fashion. Okay? So, one thing I want you to look at right off the bat is contrast this with Romano versus Kimmelman back in 1984, where right off the bat, first thing in the opinion, the court orders that the municipal courts, in fact all courts in New Jersey, take judicial notice of the fact that the breathalyzer is a impeachably accurate, scientifically reliable instrument for measuring the blood alcohol level of living human beings. This is not that at all. This is a much more measured, nuanced approach toward utilizing this instrument in the prosecution of drunk drivers in our state. Now notice, you have to slide now down to page 130, because this next sentence is critically important. The report and recommendations of the supplemental report and recommendations of the special master are adopted as modified. Now you'll see as we go through here, there will be recommendations that Judge King made that the court just outright rejects, others that they adopt partially but make changes to, and the rest of them, I guess, what do you think?
The opinion is not just 131 pages. You have in your materials the special master's 2 reports. You've actually got about 488 pages to read through. You'll go through it once. You'll see a lot of it you can cut out. But there's some stuff in the special master's reports that will be very helpful to you in defending these cases.
Now, this is going to be important on 2 levels. First of all, the next part of the decision clearly comes from Judge King's report. Okay, there are no cross-references where Justice Owens got the information she's utilizing. So you've got to keep in mind that throughout the opinion, there are many, many things that Judge King has in his report that they just make reference to or just put in the opinion, and you have to just assume that it was in Judge King's report. Now, an additional thing that's kind of far off in the opinion, this is another one of those kind of foundational things that you have to know about. This is on page 108 and 109 of the opinion. Again, very critical. Our analysis of the general scientific reliability of the alcohol test is grounded in part on our expectation that there will be proof that a particular device has generated an alcohol influence report being offered into evidence was in good working order, that the operator of the device was appropriately qualified to administer the test. This requirement that the test results be supported by foundational proofs for admissibility has been part of our jurisprudence since we decided Romano. There, we demanded that as a precondition for admissibility of the results of the breathalyzer, the state was required to establish 1, the device is in good working order and has been inspected according to procedure. 2, the operator was certified. And 3, the test was administered according to official procedure. Circle that, number 3, okay? Very important. And then circle this next sentence. In matters related to the alcohol test, the same general considerations that give rise to these requirements must, of course, apply. Everybody got that? So the court is continuing on the tradition of admissibility that they set forth in Romano. The next part we're going to be discussing is number 3, that the test was administered according to official procedure, because this is going to be the first big battleground as the law develops over the way to utilize and implement the alcohol test in prosecutions. Okay, but everybody got this? These are all pieces of the puzzle you got to kind of string together. Okay, let's talk about proper administration of the test. This is the first thing the court talks about. This is 1950s technology we're using up here in honor of the breathalyzer. Remember, Justice Howens, it was not a state trooper, okay? She didn't wake up one day and automatically know how to operate an alcohol test. They're getting all this from Judge King's report, right? These are Judge King's findings that the court is adopting. This is how the machine operates. Operators must wait 20 minutes before collecting a sample to avoid overestimating readings due to residual effects of mouth alcohol. The software is programmed to prohibit the operation of the device before the passage of 20 minutes from the time entered as the time of arrest. Moreover, the operator must observe the test subject for the required 20-minute period of time to ensure that no alcohol has entered the person's mouth while he or she is awaiting the start of the testing sequence. In addition, if the arrestee swallows anything or regurgitates, or if the operator notices chewing gum or tobacco in the person's mouth, this is a party, the operator is required to begin counting the 20-minute period anew. Dr. Menzel, could you talk about this a little bit? What's this all about?
This is the first time that something has been expressed an opinion that we all knew about. You have to, the officer has to watch the subject for 20 minutes. But this opinion is important because it clarifies who has to do the watching. It's the operator. You can't have the situation where an arresting officer brings in the subject, hands him off to the breathalyzer operator, and then they somehow are able to dovetail those 2 observation periods into a single observation period. And that makes sense because the arresting officer from the scene is doing a number of things, not the least of which is driving. You cannot look at a subject and drive a vehicle at the same time. At least you can't do it safely. So this becomes a litigatable, whatever.
How about litigious?
You can try it any time you have a case where you have to defend.
Can anybody else fill in for him today, please?
Because looking at the arrest time on the alcohol influence report and comparing it to the test time is not enough. The facts you need to uncover really can only be uncovered at trial.
In a certain sense, the arrest time is not really relevant.
It's really not, because for one thing, you might try to match it up with CAD records and other reports, but the bottom line is there's really very little synchronization in most departments between those times.
I disagree with some of that. The opinion mentions time of arrest as being the time of that the clock starts with the defendant. And if the arresting officer is the operator of the alcohol test, then that entire time can be used from the time of arrest to the time of stop, so long as there is no interruption in the arresting officer observing the defendant. In other words, in my estimation, reading this opinion, if the arresting officer puts the defendant under arrest and then goes and does an inventory check on the defendant's car at the scene of the arrest, then later comes back into the car, the time of arrest then becomes irrelevant for the 20 minutes.